Unsafe wiring, your lights flickering on and off, no back plates on your electrical outlets, those sorts of things. Unsafe flooring or steps, unsafe ceiling or roofs, and obviously one that leaks is unsafe. Unsafe chimneys or flues. Chimney fires are common, and that's a very dangerous thing. Lack of potable water. Operable locks on all doors leading to the outside. Now it says operable locks, not deadlocks, so that's a problem for a lot of students. Broken windows or lack of operable locks on all the windows on the ground level. Operable toilets, operable bathtub and shower, rat infestations, excessive standing water, which would give rise to insects. When you move into an apartment, pay attention to the inspection sheet that the landlord gives you, and note if there's already a hole in the wall or there's a broken window shade, because you can believe when you move out, the landlord's going to say you broke that shade unless it shows up on there. It's a standard of reasonable care, and it's what a reasonable man would do or should have done in that situation. And it will be, and unfortunately for our students, sometimes the standard is higher because our students are deemed to be adults and very intelligent and educated. They can't hide behind, well, I'm just a college student, I didn't know you had to do this. At common law, that is without an agreement that you sign in your lease agreement, the landlord has no right to come into your apartment. It is your castle. Police don't have a right either. So most leases say that a landlord can come in to do, at reasonable hours, to do routine maintenance, inspection, and so forth. When you give up that right, that means that they can come in. Security deposit belongs to you. The landlord is permitted to keep it in their checking account interest-free. At the beginning of the lease, they're required by law to give you a written notice of what bank, what trust account and a bank they have that in. At the end of the lease, they have to give you a written accounting within 30 days, and then there's some modification that they can take a little bit longer if they need to, up to 60 days, to tell you why they're withholding. And the law spells out they can only withhold for lost rent, actual costs that they incurred as a result of your negligence. That is, if you don't leave the apartment clean and they have to have it cleaned and repaired and so forth.